The first case to come before us is State versus Fleming. Both sides ready to proceed?
Yes, sir.
All right, you will have up to 5 minutes to reserve and 15 minutes obviously to argue with 5 minutes to reserve. Up to. Yeah, I better say that. Only because some people will take it that I'm saying you have to take 5 minutes and you don't.
I'd like to reserve 4 minutes.
That's great.
Go ahead. Good morning, Your Honors. My name is Giovanna Scaletta-Bremke. I represent both Jerry and Jason Fleming. This was a case tried to the bench trial, but both brothers, Jason and Jerry Fleming, were tried together. So for purposes of appeal and our argument, we're just together. Sure. The only assignment of error in this case is that the convictions were against the manifest weight of the evidence. Essentially what happened were the two brothers were rehabbing a house down the street. They passed a home. They noticed that it was abandoned. They came back. They parked a truck, a large truck, in front of the residence, backed the truck up, entered through a window using a flashlight, and started to remove items, put them in the truck. And they noticed that the home was covered in human feces, there was debris everywhere, and that it had been picked through many, many times prior, presumably by scrappers.
So what would be the relevance of that information that they gained once they entered the house?
Well, they did notice that the house was abandoned when they were driving by, but further evidence that the house was abandoned, because that's obviously an issue here, was that the intent to theft, or breaking and entering, that the intent to commit the theft offense, that the property was abandoned. So there was a conviction for breaking and entering criminal tools, both felonies to the 5th degree. The brothers, made no attempt to conceal their presence, and the two areas. And I actually know that the house was later demolished, actually prior to this even going to trial. The two factors that the convictions are against the manifest weight of the evidence are the first one being stealth, that the brothers didn't use stealth to enter the residence. And there was 2 cases cited in the trial court, and that was State versus Bullard and State versus Sims. The key to those two, in Bullard, the defendant had broken into an abandoned Sparkle Mart, I believe, and it was when the police had arrived, it was crouching in the corner, didn't come out to any police calls. And similarly in Sims, there was an incident in a parking garage, and the defendant was crouching in between the vehicles. In both of those cases, the convictions were upheld, but in this case, it's significantly different in that these brothers, once the officer had arrived, it was an officer and a canine officer, they announced their presence, the brothers automatically came out, their hands up with tools in them. They said they didn't want any bother, they weren't trying to conceal themselves, they weren't trying to crouch. They also pulled the truck up to the front of the residence. They were using flashlights. They weren't making efforts to conceal themselves. And the fact that the officers were even called there by neighbors is that they weren't concealing themselves. The trial court, if you page 8 of the brief, of my brief, the trial court had made 3 findings or 3 reasons for the fact that he had said that there was stealth. The 3 reasons being that the brothers had no legitimate purpose to be on the premises, that they gained entry through darkness using flashlights, and that the one brother, Jerry, had testified that he knew that they weren't supposed to be on the premises. To address those issues, I guess 2 of the issues talk about that they didn't have a purpose, and that they acknowledged that they shouldn't have been there. We agree that they were trespassing, there's no dispute of that. But I guess the primary question was there stealth, and
Let me ask you this, because I know you cited those two cases, distinguished them and so forth, but I guess I'm still not quite understanding the whole thing, because isn't stealth, don't we look at stealth as to gain entrance, not hiding from the police once they're in there? I understand, you cited those cases, but I thought the whole point was, you gained entrance to the premises through the use of stealth or by stealth.
right.
And so this was at dark.
Right.
Evidently, you really couldn't see the truck the way it was situated. And they went through a window.
There is testimony, that is true. There isn't a good definition for stealth. It's not in the revised code, but there has been the definition of any secret or sly act to gain entrance. So to address that point, there is a lot of testimony about the way that they went through the window and how they went through the window because it would be difficult to go through the door.
The door was ajar.
It was ajar, but I believe the way the testimony reads is that it would be difficult to open it because of the debris that was blocking the door, and that's why it was easier to go through the window, and they could see what the potential hazard would be if they entered through the window, because they weren't sure what would be behind the door. But to address that...
Anytime you go through a window to gain entrance to a house and talk to, I apologize, doesn't that seem like stealth? I guess that it would be one thing to consider. The other thing would be that they used flashlights so that they weren't, and even though it was dark, they were able to be seen by the flashlights. Additionally, there was conflicting testimony as to whether the car could be seen. The brothers maintained that the car could be seen. It was parked out front. It was a large truck. So those factors, I guess to the entrance factor, they did go through the window, but they used flashlights, and potentially that could even make them seen more if they were going through a window as opposed to just opening a door that was already ajar. The second factor would be that the state didn't meet their burden of persuasion on the intent element of the breaking and entering, because there was no purpose to commit a theft offense inside, and that is because the property was abandoned, and there's no dispute that they took the property. Brother testified to that, but that is that is clear from the testimony. Jerry testified that and it's on page 10 of my brief, that he first said that he believed the city owned the property. I think he did later clarify that to say that he believed that the property was going to go to the dump. So the intent there was that the brothers believed the property was abandoned, that they could take the items, and the property later was demolished. So the intent element wasn't there to commit the theft offense because the property was abandoned.
They were there in an effort to get something of value, correct?
Presumably.
I think that was their testimony.
Right.
They were just going to try to salvage something. Is there any testimony that they had some knowledge that the owner wasn't going to try to retrieve whatever was there of value before the house was torn down?
Well, there isn't, but the belief was that the owner, there's testimony that they didn't know who the owner was.
Okay, well that's, if you steal a car and you're not sure who the owner is, I don't think that's a defense to the theft.
Right.
But if they were taking something of value and they didn't know whether the owner was going to want to retrieve and salvage the same property they thought had value, how could they believe they had permission to take it?
Well, their belief was that nobody was going to, that's the testimony, was that the stuff was just going to go to the dump, that it had been set there, that it had been abandoned for so long and it had been set to be demolished, and that nobody was going to benefit from it. That it was just going to go, and I think there's even testimony that says that they thought it was going to go to a landmine, so that nobody would benefit from it. So I guess there is testimony that there wasn't any testimony that the owner would value, but that nobody was going to value. I'd like to reserve the rest of my time.
Thank you. May it please the court, my name is Natasha Guerreri and I represent the appellee of the state of Ohio in this matter. I guess first to the statement with regard to, or the testimony of Jerry regarding the condition of the house actually once he entered the house. The state would submit that at that point he already committed the violation of breaking and entering at that point because he entered the home. He was required prior to actually committing any of these offenses to have established that this property was abandoned. And the property owner actually testified here. He stated that at that time in October of 2013, his intention was to repair the home. He did state that scrappers had been in that residence previously, and his intention was to gain finances in order to repair it, to actually continue to use the property. Therefore, obviously, the property, based upon his testimony at that point in time, was not abandoned. He stated that his intention to continue using that property. And with regard to the actual demolition of the property, again, that's an after the fact piece of evidence here. At the time that they went into the property, obviously it wasn't demolished. This was something that happened later on the next year, so that really doesn't have any bearing to the issue of abandonment in this particular case. Here, looking at the factors with regard to stealth here, and looking at the facts of this case, the state would submit that the court did correctly make that determination, correctly made the determination that the brothers did in fact gain entrance into this residence by use of stealth. Again, it was night when this took place. There was testimony that there were no porch lights on this residence, so it was dark. The Officer Ball testified that he did not even notice that the truck was actually parked within the driveway until he was actually on the property because it was parked further toward the back of the residence. Again, one of the brothers testified, Jerry, that they gained entrance through the window. Again, another factor which would indicate that they used stealth here. And he also testified that they could have gone through the front door here. Therefore, just based upon all of the circumstances there, the trial court did in fact make the correct determination that they did gain entrance by stealth here. And with regard to the abandonment, other than the actual homeowner testifying and stating his intended purpose to continue using that property, Jerry testified that his belief was that the city actually owned the property, and that he believed that at some point in time the contents within would be taken to the dump. However, he did not provide any testimony or evidence with regard to the intention at that time that that was actually going to take place. Furthermore, he testified that he received absolutely no permission either from the actual owner or even from the city in order to gain entrance into that residence and actually take items out. And on the scene, both Jerry stated that he knew he was not supposed to be there. Jason admitted that they actually took some items out of the house and placed them in the truck, and there were items contained within the truck. Therefore, again, here, the Flemings were not able to establish that the property was abandoned, and the trial court, in weighing all the evidence, who actually was able to witness them testify and determine their credibility, his determination should be granted deference here, in that he made the determination that, in fact, they did not have a true belief that this property was abandoned prior to them going into and taking some of those items.
And I think one of the briefs, I can't remember exactly how it came about, but somebody probably you said that there was a sign about the condemnation but it was not attached to the house anymore.
Correct, Your Honor. At some point in time, there was a sign there, but at that time, Jerry did testify that it was not there that night, that they actually gained entrance into the home. So that's, I guess, some further evidence to show that maybe at one point it was intended to be demolished, but maybe at that point it was not. Obviously, later on it did, but again, that has no bearing on
Well,
what
the
actually
reason
took
why I
place.
ask is because usually, obviously, it's a requirement that you post those, so, so I was just wondering about any other further testimony in regard to that sign or anything.
That's the only testimony that I was able to, that I remember actually being there, that at one time it was there, but at that time it actually was not. There are no further questions for me. The state would just request that the decision of the trial court and the conviction of the sentence be upheld.
Thank you.
Thank you.
You have just a little less than 5 minutes.
Okay. To address the stealth issue again in the entrance to the property, the state contends that the window, that they entered the window, that was a SIAC. We previously talked about that. I guess, besides the safety issues of entering the door, entering the window would arguably be less sly or secret because it would make them more noticeable to the neighbors and the flashlights as well. There is some talk in the briefs about there being no porch light on, but the condition of this house didn't make that possible. The house, lots of testimony about the condition of the house, how it was in total disrepair. So the light wouldn't go against, shouldn't be, go against this, the Flemings acting sly or secret because it wasn't an affirmative act of them to keep the house dark. And in fact, they had made an attempt with the flashlights to illuminate the house, making the presence aware. And as far as the abandonment factor, the state argues that the owner's intent was to repair the home, but there is testimony that that was his prior intention at this point, didn't have the money to repair the home, that it was set to be demolished. It was demolished a short time after this. That sign was up, and the brothers had driven by. They were, like I said, they were rehabbing a home just down the street, and they had driven by many times and saw that sign, which again goes to the intent that the property was abandoned. The fact that Mr. Fleming says that the city owned the property, I believe that's his layperson's interpretation of the ownership. I think that he clarifies that by saying that that he didn't think anybody had owned the property, that it was just the property was going to go to the dump. Thank you.
Thank you. Thank you to both sides. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. And you can also look on the website.